Judgment in the matter of Argentum Exploration Limited against the Republic of South Africa.
On the 23rd of November 1942, the SS Tilawa was sunk in the Indian Ocean by 2 torpedoes fired from a Japanese submarine. On board, in addition to its passengers and crew, was a cargo of 2,364 bars of silver being carried from Bombay to Durban. The silver belonged to the Union of South Africa, now the Republic of South Africa. It had been purchased for the predominant purpose of being made into coin by the South African Mint. The silver had an estimated value of approximately $43 million at 2020 prices. In 2017, the silver was recovered from the seabed at a depth of some 2.5 kilometers by a specialist salvage vessel. It was carried to the United Kingdom and declared to the receiver of wreck. Argentum claims to be the salvor of the silver and argues that it is entitled to a claim for voluntary salvage, having retrieved the silver in the absence of any prior agreement with South Africa. Argentum brought its claim for salvage in rem against the silver in the High Court. An action in rem is a special form of proceeding which can be brought against a vessel, or, as in this instance, its cargo, and is to be contrasted with an action against a person, an action in personam, for enforcing a claim against such a cargo. The Republic of South Africa filed an acknowledgement of service solely for the purpose of challenging the jurisdiction of the court. South Africa argues that the High Court has no jurisdiction to hear Argentum's claim because it is entitled to immunity in accordance with Section 1, subsection 1 of the State Immunity Act 1978 and/or Article 25 of the Salvage Convention. Argentum argues that South Africa does not have immunity because the exception to immunity under Section 10(4)(a) of the State Immunity Act 1978 Act applies. Under Section 10(4)(a), a state is not immune as respects an action in rem against a cargo belonging to that state if both the cargo and the ship carrying it were, at the time when the cause of action arose, in use or intended for use for commercial purposes. It's common ground between the parties that the SS Tilawa was in use for commercial purposes when carrying the silver. Following the High Court's judgment in these proceedings, it is also common ground between the parties that the silver on board was not intended for use for commercial purposes. Its predominant intended use was the sovereign purpose of minting currency. As a result, the central issue between the parties on this appeal is whether the silver was in use for commercial purposes within Section 10(4)(a) when it was being carried on board the vessel in 1942. The High Court found in favor of Argentum on this issue, holding that the silver was in use for commercial purposes, as did the majority of the Court of Appeal. South Africa now appeals to this court. The Supreme Court unanimously allows South Africa's appeal. We hold that the silver was not in use nor intended for use for commercial purposes at the time when the cause of action arose, and so the exception to immunity cannot be relied upon by Argentum. Therefore, South Africa is entitled to immunity from Argentum's claim in rem against the silver. Lord Hamblin and I give a joint judgment with which the other members of the court agree. The essential question is whether the silver was in use for commercial purposes when it was being carried on board the vessel in 1942. Argentum argues that the silver was in use for commercial purposes because of the commercial arrangements under which it was being shipped to South Africa. It submits that the transactions or activities which determine the use to which the government was putting the silver in 1942 were the International Commercial Contract of Sale on FOB terms, the International Commercial Contract of Carriage on board a merchant ship, and the bills of lading issued thereunder. The court rejects these submissions. To say that the silver was in use while it was being carried on board the vessel does not accord with the ordinary and natural meaning of those words. Cargo sitting in the hold of a ship is not being used for any purpose, commercial or otherwise. While the silver was undoubtedly the subject of commercial arrangements for its carriage, it would be a distortion of language to say that it was being used for the purpose of those arrangements. As Lady Justice Elizabeth Lane succinctly put it in her dissenting judgment in the Court of Appeal, it was being carried, and that's all. Further, if Argentum's interpretation were correct, it would defeat Parliament's intention to make separate provision for state immunity in respect of actions in rem against state-owned cargoes, as compared with actions in personam for enforcing a claim in connection with such a cargo. In the case of an action in personam in respect of such a cargo, immunity from suit is lost if the ship carrying it was in use or intended for use for commercial purposes. In the case of an action in rem against such a cargo, Parliament has imposed additional threshold criteria. Immunity from suit is lost in an action in rem only if both the cargo and the ship carrying it were in use or intended for use for commercial purposes. If it were right to say that when a cargo is carried on a commercial vessel, it is in use for commercial purposes, the additional threshold criteria for actions in rem would be made redundant. Proceedings in rem are far more intrusive into the rights of a state over its property than proceedings in personam. The mere issue of a claim in rem gives the claimant the status of a secured creditor and encumbers the property with that claim. The property is the subject matter of the claim, and in relation to claims for salvage of cargo, there is a maritime lien over the cargo. Jurisdiction is established merely by the presence of the property within the jurisdiction. The establishment of jurisdiction puts the property owner in the difficult position of facing a choice between appearing and defending the claim or staying away and losing the property. And issuing the claim gives rise to a right to arrest the property. There are therefore compelling reasons why more stringent criteria should be satisfied before a state is denied immunity. Section 10 of the State Immunity Act 1978 was enacted to enable the United Kingdom to ratify the Brussels Convention for the Unification of Certain Rules Relating to the Immunity of State-Owned Vessels of 1926. The provisions of that convention further support South Africa's interpretation of Section 10(4)(a) and the conclusion that Parliament intended a distinct approach for immunity in the case of proceedings in rem. The majority of the Court of Appeal rejected South Africa's submission that, because the silver was not in use at all when carried on board a ship, the focus of the court's inquiry should be on the government's intended use for the silver. The Supreme Court holds that the majority's approach to the relevance of the intended use of the cargo in the application of Section 10(4)(a) was erroneous. It inappropriately allowed the cause of action in salvage to influence the interpretation of Section 10(4)(a), which covers other actions in rem in addition to salvage. It also relied upon an overgeneralization of the operation of the distinction between sovereign and non-sovereign activities in customary international law. The Court holds that it is not necessary to read down Section 10(4)(a) under Section 3 of the Human Rights Act 1998 in order for it to be compatible with the right of access to a court under Article 6 of the European Convention on Human Rights. First of all, in enacting Section 10(4)(a), the United Kingdom Parliament had the legitimate aim of giving effect to the restrictive theory of immunity in international law so as to enable it to become a party to the Brussels Convention. The measure is a proportionate means to achieve that aim. Furthermore, the immunity claimed by South Africa applies only to proceedings in rem, and it is common ground that it does not preclude proceedings in personam. More generally, in the circumstances of the case, the grant of immunity from proceedings in rem based on the intended use of the property for sovereign purposes conforms with and is required by general principles of international law. Accordingly, whether one considers that Article 6 of the European Convention on Human Rights is not engaged because immunity is required by international law, or that compliance with international law is a justifiable interference with Article 6 rights, the answer is the same. For these reasons, the Court concludes that South Africa is entitled to immunity from Argentum's in rem claim against the silver. The Republic of South Africa's appeal is allowed. Finally, we should record that on the 3rd of May 2024, we were informed by the parties that a settlement had been arrived at in this matter on the 26th of April 2024. The parties have agreed that we should nevertheless hand down this judgment, and we are satisfied that it is appropriate to do so. The court is now adjourned.